Hello everyone, I am Anupama Sharma, Assistant Professor at Jindal Global Law School. I am here to discuss with you the first optional protocol to International Covenant on Civil and Political Rights. This is Module 3. This module will give an understanding of the purpose of the optional protocol and its effect. It will reflect on the importance of human rights committee's role with respect to complaint received by the individuals. It also discusses the conditions required for state to be bound by this optional protocol and the procedure for denunciation of the protocol. Moreover, if the state party needs to propose any amendments to the protocol, then the procedure that is to be complied with is also discussed in this module. Students, after studying this module, are expected to have an elementary understanding of the text of the optional protocol and its scope. As explained in Module 2, Part 4 of the Covenant deals with the process of establishment of a Human Rights Committee which has certain responsibilities to fulfill. The Covenant also specifies that procedure in case of communication received by one party by the other party regarding the non-fulfillment of duties under the covenant by the former state. Part 4 clarifies the role of the committee in such situations. This optional protocol is in furtherance to the explanation and provision provided by the covenant and helps in achieving the purpose and objectives of the covenant. It elaborates on the role of Human Rights Committee and provides the state parties with an option to abide by the optional protocol and give the committee to authority to consider the concerned communications by individuals. Optional Protocol Article 1 to 7. The requirement of approving involvement of the Human Rights Committee is essential not just to ensure that the provisions of the covenant are implemented well and the objective is achieved, but by giving the prerogative to an option of abiding to the protocol assures autonomy to the state parties. It is possible for state parties to abide by the covenant by becoming a member to it and yet refrain from application of this protocol. As the name suggests, it is optional in nature. By agreeing to the provisions of the optional protocol, a state party gives the authority to the committee to receive and consider communications from the individuals against the state which is a party to the covenant. It should be noticed that only communications which deals with state which is a party to the ICCPR covenant will be considered by the committee and for no other state which is not a party to the covenant. The optional protocol elaborates the procedure for filing of communication by the individuals. The communication must relate to violation of any right enshrined of the covenant. It should be filed only after exhaustion of all the domestic remedies and should not be under consideration by any other international investigation. Once these conditions are fulfilled, an individual can file a written communication to the committee. If any of the communication is anonymous or incompatible with the covenant, or an abuse of the privilege given to the individuals to file a communication, then the committee has the power to deem such communication as inadmissible. Once the committee receives a written and admissible communication, it can provide the same to the state party alleged to be the violator of the rights enshrined under the covenant. The purpose of this exercise is to provide state with an opportunity to clarify their actions and submit a written response explanation within 6 months. The committee will then consider all submissions from the both sides, individual as well as the concerned state party. It can hold closed meetings for the process of examining the communication, post which the committee will send its observations to the individual as well as to the concerned state party. In cases where the complaints are of an urgent nature, then the committee may request the state to prevent the irreparable damage by adopting certain interim measures till the time the committee is able to come to a final decision on the communication which it has received. The decision of a complaint is either in favor or against or partly both. The decision is then communicated to both the author and the state. Now we will move on to Articles 7 to 14. These articles provide with the provisions relating to signing of the protocol by the state parties and the procedure for proposing and acceptance of amendments. It is provided in the optional protocol that if any state is a party to the covenant, then the optional protocol is available to it for signing. It is subject to ratification and is open to accession by any such state party to the covenant. The Secretary General provides with the state parties to the covenant about the deposit of each instrument of accession or ratification, whichever has been adopted. The provision under the optional protocol, once ratified and accession is submitted, will extend to all parts of the state devoid of any limitation from 3 months from the submission of ratification or accession, depending on whichever has been submitted. Just as Article 51, which was discussed in Module 2, provides with procedure for proposal of amendments by the state parties and how the amendments are accepted and further included in the covenant. Similarly, Article 11 of the optional protocol provides with the procedure for amendments to the protocol. It states that the state party to the protocol can propose the amendment which is further communicated to other state parties by the Secretary General, seeking their response to whether a conference need to be organized for discussion or not. It is organized if not less than 1/3 of the state parties favor such conference. If any amendment is accepted by the majority in the conference convened by the Secretary General, then that particular amendment is sent further for approval to the General Assembly of the United Nations. It will be included in the protocol if approved by the General Assembly and accepted by 2/3 majority of state parties to the protocol, and it must be in accordance with the constitutional process of each of these state parties. Only those states who accepted the amendment will be bound by it. The rest can continue to observe the remaining protocol as it is. Article 12 of the protocol provides a discretion to the state party to denounce the present protocol by following specified procedure of written notification, which is addressed to the Secretary General of the United Nations. Only after 3 months from the receipt of this notification by Secretary General is the denunciation functional. I am now going to refer to an information box which has been taken from the United Nations Human Rights website, which elaborates upon the details on how a covenant can be rejected or denounced by the state parties. Can the covenant be rejected or denounced by a state that no longer wishes to be bound by it is the question that needs to be addressed. Another question is, what about new states emerging from the breakup of an old state that was a party to the treaty? What happens to their stance with respect to the covenant? Unlike many treaties, the concluding provisions of the covenant do not provide for denunciation of the treaty, allowing a state party to withdraw from the treaty regime. In these circumstances, the committee has taken the view that in the light of the particular character of the human rights treaties, such as the covenant, which extend basic rights and freedoms to persons within a state party or parties, jurisdiction, their rights and freedoms may not be withdrawn once confirmed. Accordingly, once a state has ratified the covenant, it is not permitted to withdraw from its obligations by denouncing the treaty. Likewise, state parties may not denounce the second optional protocol, which does not contain any provisions on denunciation either. In contrast, the first optional protocol specifically sets out a denunciation procedure. A related issue is the situation in terms of ongoing applicability of the covenant when a state party to the covenant breaks up into a series of successor states. Applying a similar approach, the committee has taken the view that a successor state succeeds to a predecessor state or states' obligations under the covenant. Thus, for example, the committee views Kazakhstan as being bound by the covenant as a successor state to the USSR, which was a state party at the time of its dissolution. Generally, this precise situation does not arise as successor states have acted to confirm the applicability of the covenant in their particular jurisdictions, such as by making a declaration of succession. Similarly, when the United Kingdom and Portugal, as states parties to the covenant, returned sovereignty over Hong Kong and Macau respectively to China, China agreed to apply the covenant obligations in those territories even though it was not itself a state party to the covenant. So in this particular optional protocol, we have learnt that how individuals can submit a communication and a complaint for breach of their rights to the committee. The format, the procedure has been laid down, and also what happens after the submission of such complaint and what are the duties or the procedure to be followed by the committee has also been laid down. It has also been discussed in this protocol that the state parties, if wish to denounce a particular part of the treaty, can do so by following the procedure as explained in the protocol. It has also covered the situation where the states split and the successor state is in a state of confusion whether to continue following the treaty, the covenant or not. Fortunately, such situations have not arisen much where the successor states have refused to follow, but still the protocol has been made able enough to cater to such situations. Thank you for listening to this module.